I want to start by saying that if you follow this EFCC thing from beginning, there is always controversy in every appointment. And so also is their exit, starting from the first person, Badu, the last man now, that is Bwala. The appointment always generate controversies and a lot of discussions on television, and at the end, the dust will settle down. I'm very happy that he has quoted a particular section, and that is that section 2 of the EFCC Act. We look at what are the requirements for you to be a chairman of EFCC. You must be a serving or retired member of the security agency or law enforcement agency. Security or law enforcement agency. And everyone agrees that this man that has just been appointed was once a worker within a security enforcement agency, and that is EFCC.
You use worker advisedly?
Yeah, yes, officer. He was an officer, chief of staff, or at the time he became the secretary of that particular agency. Then secondly, he must be of a status of not less than, not below the rank of Assistant Commissioner of Police. Then the third qualification is that he must have or possess cognate experience of 15 years. Now that issue of cognate experience is where we're having issue, and the definition is, does that cognate experience mean that he must have it within any of the security or law enforcement agency? The Act itself was not specific. If you look at the Act, it didn't say that that cognate experience must be garnered from the security or law enforcement agency. Look at it. It didn't say so.
So what about the base interpretation?
No, wait now. So cognate experience, what is the meaning? It is professional experience. And those who are pushing this particular young man as a chairperson gave you reason why they are pushing him. They say, one, he is a lawyer for 22 years. And if you check his profile, that this is a man who has been a compliance regulatory consultant with specialization in fraud management and corporate intelligence. And that he was once a member of the fraud advisory panel in UK. And that he has been to Harvard University in terms of training concerning fraud. And a lawyer for 22 years, and having worked either 5 or 6 years in a security and law enforcement agency, has garnered that cognate experience you are talking about. Since the Act itself was not specific as to where that cognate, if you look at it, it didn't say cognate experience within, because that's how, where that particular problem is coming. People were saying, oh, it is within the, law enforcement. It didn't say so. The Act itself was specific, was not specific. It said so, 15 years cognate experience. It didn't mention that it must be, that you must continually be in a security agency before you get it. So they now say the man is qualified. Okay, just let me just finish now. He's qualified by virtue of the fact that he has been an officer of law enforcement agency, that he has practiced law in an area that is related to enforcement of law, that's fraud, for more than 15 years now. And that if you put all that together, that qualifies for the cognate experience, because that is the only place they are looking at, this place disqualifies him. But the Act itself was not specific as to where the cognate experience should be. When you are looking at interpretation, as my brother has rightly pointed out, there are 3 methods, there are 3 schools. There is a school of, if the law is very clear and unambiguous, give it its literary meaning. Don't ever come with any importation of any other method. Then secondly, if giving a literary interpretation to a legislation will create some level of absurdity, then you apply golden rule. That is the second school of thought. You apply golden rule to avoid absurdity. Then the third one is mischief rule.
What is golden rule, sir?
Golden rule is that you are looking at a piece of legislation now, and you look at it that if you apply literary rule interpretation, it will create some level of absurdity. Then you now look towards a particular interpretation that would now avoid that absurdity.
Which rule are you applying?
Then the third one is what you call mischief rule. You ask yourself, what was the intention, what was the law before the legislators came in? then what was the mischief that the new act now wanted to cure? That is the mischief rule. We are running away from the Nigerian police as being incapable of handling corruption. You created an agency by way of avoiding Nigerian police. And then you now, according to you, says that that particular agency must be run by the same people that you are running away from. Because now really...
That's a different matter.
Yeah, I'm saying...
So which rule did you apply in this?
Now the rule that you will look at for those who are advocating that this man should be, will be this issue of mischief rule and even literary rule. Let me finish.
For this section too,
literary
right?
rule, yes. Now, because the cognate experience was not specific as to where you are gathering it from. Look at it. Look at the law. Let them bring it on the television. It didn't say cognate experience within any. It said cognate, 15 years cognate experience. Look at it. Look at the law. Let them show it on television, whether there was any particular reference to any law enforcement agent. So my brother has rightly pointed out that if a law is very clear and unambiguous, don't import any other thing other than that literary interpretation. He agrees with me.
So this is the point. The reason, you see, look at it, and I will give you in contradistinction, Section 3, Sub 3 of the ICPC Act, to tell you that this act is very clear and unambiguous. Now, the number one is that the person must come. He must either be a serving or a retired member of any of the government, security, or law enforcement. Baseline. Number two, he must not be below the rank of Assistant Commissioner of Police or its equivalent. The reason for the use of the word its equivalent in this context is because police is mentioned. So if you are bringing somebody from DSS, he must not be less than the rank that is equivalent to the Assistant Commissioner of Police, which in this case will be Assistant Director. If you are bringing from DIA, if you are bringing from NIA, then he must possess cognate. Cognate means relevant. 15 years relevant experience in law enforcement or security.
It's not there.
Because it has, I'm coming now, it has already been established he must come from the agency, security or law enforcement. He must not be below the rank of Assistant Commissioner of Police. He must have cognate experience. Relevant experience to that field. If you are bringing somebody from DSS, he must have 15 years. And let me even tell you, they mentioned the resume of Olukoyede. It says cognate experience. It didn't say cognate certificate. Olukoyede's profile that is being banded and shared are profiles that are imported from the corporate profile of the chambers that he worked with, which is that chamber is an expert in fraud management and the rest. Now, there is a distinction between you go and obtain a training, that is, you go for a course, 5 days, 1 week, or whatever, and get certification, and experience that is acquired dealing with live cases. Olukoyede, even with the little stint he has had in EFCC, has never investigated, has never presided over. You would have asked them, Mr. Chamberlain, when they said he's a fraud expert, he's this and that, I said, the expertise, was it obtained from a live case or a seminar? If you look at FBI, you look at NCA and all of them, all the individuals that are heading or have ever headed those agencies were individuals that came in through the rank. Olukoyede was not pensionable as at the time he left. Let me even tell you a deeper picture. The president ought not to have even appointed him in any federal government work. Do you know why? There was a Justice Salami committee, panel, sorry, that sat and determined an indictment against him and Mago and the rest. And that committee sat like a tribunal. They took evidence. Olukoyede and Mago and the rest were represented by Wahab Shitu, senior advocate. There was a hearing. It took weeks. Then there was a verdict by that, which now indicted him.
But Mago was promoted.
No, that verdict of the report, I'm saying that indicted them. It is police. He was indicted and removed from EFCC, right? Now, after it was gazetted, if you ever want to jettison that, you have to challenge that and quash it in the court of law. Tribunal of inquiry. So, and then the second interpretation that I say it will just oppose that is that, you see, if you look at Section 3, Sub 3 of the ICPC Act, you will know that it is deliberate that EFCC Act is couched that way, because in ICPC Act 3 and 3, it says the commission shall consist of a chairman and 12 other members, 2 of whom shall come from each of the geopolitical zones. Now look at the composition. A retired police officer not below the rank of commissioner of police, a legal practitioner with 10 years post-call, a retired judge of superior court, a retired public servant not below the rank of a director, a woman, a young man or woman not less than 21 years or 30, a chartered accountant. Then if you look at 4, in the case of the chairman, he said the chairman shall be a person who has held or is qualified to hold office as a judge of a superior court of record in Nigeria.
But here it was specific.
Correct. So what I'm saying is, with this provision now, Olukoyede can fit into it here because one, is a lawyer who has put in years of experience beyond that, and it says a judge or a lawyer. Now, the EFCC Act, the reason why you don't see a lawyer indicated there is because it relates to members of the government, security, or intelligence, and they could be lawyers. Ribadu was a lawyer. Farida was a lawyer. But they were not recruited because they were lawyers and they had experience as lawyers. They were recruited because of their experience in law enforcement. And thirdly, when they said it was a departure from the police, I agree. But that was the reason why EFCC was created. Bwala was not a police officer. He was a cadet trained. FBI, if you go to FBI, you see this SSS before now was being led by military because military created it. At some point, the DSS came to the rank, produced their own training, and then produced their own leaders. So if you look at this act, you will agree with me, with the greatest respect, that Olukoyede does not fit in. They are approbating and reprobating. Why don't you just drop about his stint in AFCC and say his 21 years post-call is sufficient? They still want to import that. And then they will import. Now, if you want to import his stint in AFCC, why don't you then abide by the mandatory provision that says it has to be 15 years?
There was no mandatory provision, my brother. There is no mandatory provision with the cognate experience. Look at it. It stands alone. It said 15 years cognate experience. He never mentioned in any law enforcement agency or security. Look at it. The law is very clear. Bwala himself, you mentioned rightly. You know, people also raise issue that he is not a police officer as properly defined under that act. And people now say, look, he has had a training under EFCC, school and all that. For that alone, that qualifies him.
Olukoyede was not trained by EFCC.
Yes, well, I'm coming now, but I'm saying, people are also saying with regards to Lu, that look, he has had a stint in that particular agency, that law enforcement agency, for not up to 15 years now. Wait, now, I'm saying that cognate experience cannot be tied to law enforcement. Look at the law. Now, you came. It's clear. He didn't mention that it must be law enforcement agency. So, we raise all these issues in order to educate the people. Now, know it that this particular appointment is subject to confirmation by the Senate. The Senate will look at the provisions of the Act, look at whatever he has had as cognate experience in order to give him a clearance. So the appointment alone does not in any way make him now the substantive chairman of EFCC. We must get that clear. What we're doing now is to look at the law. And if there is any ambiguity, I've already said it somewhere else, can we clear those ambiguities by amending the law and make it as express as he has pointed out with ICPC law that says this is what it's supposed to be? Because there is ambiguity here with the issue of cognate experience, him tying it to EFCC, to law enforcement agency, whereas the act itself, whereas the law didn't say so. You want to ask a question, my sis?
Indeed. So I'm looking at the fact that it looks like somebody now, excuse me, a lawyer like yourselves has now gone to court.
Yes.
Mr. Opatola Victor, that's his name, and he's suing the federal government, beg your pardon, the President of the Federal Republic of Nigeria, the National Assembly of Nigeria, Attorney General of the Federation, and even Mr. Olukoyede. They're all defendants in this particular
case. Yes.
Yeah. So we'll see how that
plays out. Because the court will give an interpretation now.
Yeah, but you said that you've also pointed out the fact that almost every single appointment into the chairmanship role of the EFCC, even the exit, has, I mean, exit is it's a totally different kettle of fish, but the entrance has always been problematic. Is it a problem that can be avoided?
Yes. And that is where I say, if there is sometimes some absurdity or ambiguity in any law, what the legislators should do is to say, what is the problem with this law? Can we make it a bit simpler and clearer? Because this cognate experience is the issue. If you talk about agency, the man has been in an agency that is law enforcement agency. If you talk about cognate experience, the man has had it. But can we, agree that that cognate experience must be within the security, make it express?
So it can be non-operational.
Yes. Are you following me? Because I see no reason why you are running away from Nigerian police to really handle the issue of corruption. And you are now saying that he must always must be a Nigerian police officer to man an agency while you're running away from this. So it's contradictory. It doesn't make sense to me. So people will now say, what was the reason for even bringing that agency? Was it now to still hand it over to Nigerian police? So that's why these people now have said, wait a minute, let's look at this law once again. Because over time, he has been police, you know, manning, whether as a lawyer and all that, but police officer. And we have not had the best in terms of satisfaction. Can we look at that law and look whether there is a way we can get somebody outside the Nigerian police? And they saw a loophole. They saw a loophole, let me finish. They saw a loophole in the issue of cognate experience. That it mustn't be within the law enforcement agency. And they already, the person who has gone to court, I'm very happy that somebody's in the court of law in order to probably to get a perfect explanation and interpretation by the court. Because the law is most times, another school of thought is what the court says it is. For now, what we're doing is only debating. When the court now makes a specific pronouncement, it now becomes a proper interpretation of that particular section.
We'll take a break at this point. When we come back, we'll see if we can get a consensus on whether they agree that this appointment doesn't satisfy federal character. In just a moment, please stay with us.
Thank you for staying with us. Well, Mr. Bwala, let me come to you very quickly before I go to Mr. Ubani. You know, Mark asked a question the other time if it is avoidable, if the issue of these controversies that have to come up every time an EFCC chairman is appointed, if it is avoidable. Do you think it is avoidable? Is it something to do with the law, something to do with the interpretation? Because there is no one who has been appointed chairman of the EFCC that has not ended up in some kind of issues being raised, such as we're raising now.
Thank you, Mr. Ayo. There has never been, in my view, a controversy. When Ribadu was appointed, there was no controversy when EFCC was established. When Farida was appointed, she was overqualified because she was above the rank of Commissioner of Police. That was the conversation then. When Lamurde came, same. It was when Magu came that the first controversy started, when they said whether he was up to the rank of Commissioner of Police. And at that time, Mr. Judge, he was at the rank of Assistant Commissioner of Police. Later, the government that put him there now hurriedly promoted him. When Bawa came, Bawa, who is from the private detective, which is a correct departure from the police, came. Because it was a new thing, people were contesting it. And the question at the time was that his position in EFCC, is it equivalent to the Assistant Commissioner of Police? And it was found out that at that time he has put in 16 years, and that 16 years was about the level of the Assistant Commissioner of Police. They lay it to rest. Now, you ask whether it can be avoided. In my view, there is no even problem. Because let me tell you, in our own discipline of law, there is no ambiguity in Section 2. Because if you look at it flowing, it says, Section 2, sub 1A, the chairman who shall, the word shall, has been held by plethora of decisions of court. It gives no room for any personal opinion. It has to be complied with. Then in the compliance, it says 1 dot. The person will be chairman or accounting officer. 2, he must come from a government, not private sector, government, security, or law enforcement. 3, then down under it, his position will not be below the rank of Assistant Commissioner of Police or his equivalent, because he can be from the security or from the law enforcement. And 2, he must not possess experience less than 15 cognate. Cognate experience means related to that agency that he's working. If he's from a DSS, he must have 15 years cognate experience relating to his function in DSS. If it's from DIA, if it is from EFCC, and all is like that. People deliberately decided to import their own interpretation. That's why Weke versus Federal Republic of Nigeria classify any extraneous interpretation as illegal legislation or amendment through the back door. And that is what it is. But the deeper conversation we've taken in the case of Olukoyede is that he has not even lived up to 15 years in EFCC, assuming you want to take them on the fact that he had a stint in EFCC. That's one. And then if you take him on the stint that he's a private lawyer, the law here does not provide for any lawyer, irrespective of his experience as a legal practitioner, to be included here, because the Act says it must come from government, security, or law enforcement.
Well, Mr. Bwala, you also heard, you probably haven't been able to respond to what Mr. Ubani said the other time, that the second and the third provisions are separate. one, he must come from a government security or law enforcement. He has been in law enforcement with the EFCC. And the next one is that he must have 15 years cognate experience. And Mr. Ubani said that 15 years cognate experience is not an appendage to the previous, which is he must serve 15 years cognate experience in a law enforcement agency. What's your response to that one quickly?
So, for example, in our discipline of law, all to the Supreme Court plethora of authorities, if you look at the Act, whenever these terms are going to be used disjunctively, which is the argument that my learned senior brother here is given, that they are separate, the instrument there would have been or. Even or, if you want to add to a constitution or a statute, it has to go through legislative process. That is how important words are. And there is no conjunctive word there. I mean, disjunctive word there, or. If it says he will be a serving or retired member, blah, 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 or possess 15 years, then you will say they should be treated disjunctively. No, they are conjunctive. That is why you see number 1, number 2, number 3. It's a criteria that must be followed. Now, he said he has been in EFCC. It is not enough. You have to show he has been in EFCC for 15 years. Then show that he has gathered the experience in EFCC for 15 years. And I am even pushing the envelope further to say that appointment is the same as is not the same as recruitment, because his job in EFCC is not pensionable. If you look at the operative word there, he says serving or retired. Did he retire? Can he retire? He was sacked because he was appointed. So this is one. He was never a member. He was an appointed chief of staff, which is principal secretary. He has never investigated any case in EFCC, either in his capacity as company secretary, secretary of the commission, or as chief of staff. That's one. Two, he has never presided over operation, intelligence, or investigation. So he does not possess that experience that is called cognate, relevant to law enforcement. Okay. So they are now importing an argument to suggest that he went for course they call fraud expert, fraud management. Then we are now asking them, if he went for course, does it say cognate certificate or cognate experience?
Okay.
Because the experience that is here connotes dealing with live cases. You investigate a subject, you go for an operation. These guys are operatives, trained, armed, given the powers of a superior police officer, then the person can be a chairman.
Okay, let me come to you, Mr. Ubani. One of the arguments that some people have also put in public is that perhaps the issues being raised about the appointment of the EFCC chairman subject to confirmation by the Senate is that the man is said to be incorruptible, that there have been several attempts over time to corrupt him, to induce him one way or the other, but he's not been, they have not been able to do that. In fact, some people he has had arrested as a result of that one. Could this be corruption fighting back even before the fight starts?
Yeah, as the question you put before is the issue of controversy that usually trail any appointment of EFCC chairperson. And I think that the main reason is actually the subject matter, the issue of corruption. Corruption, you and I know, has really kept this country down. We are retarded in growth as a nation, not that we lack resources, but the fact that we have not been able to really deploy the resources that God has endowed this country with towards developing the country due to corruption. So anything that has to do with corruption fight, has an appointment of the chair has always, elicited a lot of controversy. And so this is not an exception. And it will settle down. Now, the Olukoyede as a person, let me clear the point that he was indicted by Justice Salami's report. I don't think I've seen that report. I don't think it was even tried. It was only Magu that faced the trial, during the time there was an issue, in Magu's leadership. Olukoyede was never invited or reported in the paper that he was invited for any questioning by the panel. So we need to clear all that. And I don't think there was any indictment, a report we have seen, that is circulating that shows that he has been indicted or he was indicted by any panel whatsoever. So that has to be. So issue of him being incorruptible, I don't know about that. But that can be an added advantage. I said it elsewhere, that the issue of fight against corruption is something that all of us must be very interested in. the nation is not making progress because of issue of corruption. And the people who have put over time to man that agency has not been able to satisfy the country in terms of performance. And they all come from one particular profession. Over time, we have used them. And we have seen that there are shortcomings. So must we continue in that route? And I think that this time around, the government said, wait a minute, let's look at that act once again. Is there a way we can get somebody outside the Nigerian police to man the agency so that we can see a result? And I'm sure that my brother will be interested in having, this corruption fight, being given a real chase and get the country back and recover Nigeria so that we can have a country all of us shall be proud of. Okay. So if it's incorruptible and that is a report to that effect, that again is an added advantage, and that may even lead to his earlier clearance by the Senate, because these things are what we are looking for. We are looking for a man that is incorruptible. We are looking for a man that knows the issue of elements of crime and then tell all the crack team to go towards element of crime. Why EFCC sometimes lose their case is because they don't even understand what they're investigating. If you don't know the elements of crime, you cannot be able to generate any evidence that can indict and even get a court.
All right, Mr. Ubani, there's just one more issue.
In the court of law.
Yes,
so this man is knowledgeable. This man is knowledgeable, and we shall allow him to try EFCC and see what he can make out of it.
Just
that's
one
my
more
own
issue
opinion.
from me.
You want to ask a further question?
Just one issue. We're running out of time, Mr. Bwala and Mr. Ubani. One of the issues that Mr. Falana raised yesterday is that of federal character. That for two agencies, for these two agencies, the EFCC and ICPC, both of them shouldn't come from the same region of the country. One should come from the north, the other should come from the south. What's your response to that?
I think we should be able to tell our leaders to ensure that they balance issue of appointment in public service. It's very important because the unity of this country is an issue. And many persons feel they are really excluded from governance, because they come from certain areas. I want a situation where our leaders will understand that our unity has always been an issue, and we must try to carry everyone along. I agree with him in total that in making such an appointment that is very sensitive as issue of two agencies and all that, then we must reflect our heterogeneity. We must make sure that we balance this equation to make sure that everyone is happy and carried along. We have intelligent men and women in every tribe in this country. We must not in any way at any point in time make sure that only one tribe, which has always been the case of EFCC, is only one tribe over time and one particular. But now somebody is now trying to bring it to South. But in bringing it to South, we must also make sure that other tribes and other regions are carried along in appointment, reflecting the federal character, which is very important and key.
Okay.
Let me say
yes,
this.
Mr. Bwala, please go ahead.
Let me say this.
Yes.
Good. With respect to this quota system, whatever quota system, to me is a diversionary tactics. Because even in EFCC right now, the president's disposition is to appoint a chairman from the Southwest. I don't have any argument or any objection to it. I am saying that in EFCC right now, from the Southwest, whether Christian or Muslim, they have overqualified people there. They are called Cos 1. In the next few months, they will put in 20 years. Choose from there. I'm not saying that because he has to take somebody from the north. And those who want to divert the tactics, I've seen recently, they say breaking news for the first time, a Southerner and a Christian, so that people will take away their mind from the issue of qualification and bring in sentiment. Point number one. Number two, with respect to cognitive experience, medical doctors, when they're advertising for a job, they will advertise if you want to apply. Then they will say 15 years cognitive experience. Can an accountant apply for that job and become a doctor? And then lastly, sir, with respect, the EFCC currently don't have police there. They have been so trained and they've come full cycle. They have operatives, they do operation, they bear arms, and they were trained for that purpose. If you know how much federal government invested in taking them, some of them went to FBI Academy. Why don't you take from that pool? Now, finally, sir, I beg 30 seconds. He's coming from the law firm he worked with. It's a defense-oriented. All security and law enforcement agencies are prosecutory in nature. When you bring in somebody from the defense platform to head that commission, you're bringing what we call conflict of interest and potential corruption in the system. Because the client he is defending, or the client of his friends and cronies and partners that they defended or they are defending, they are likely going to compromise the system. That is the reason why we hold the view. From the provisions of the Act, no ambiguity. From the issue of morality, and I'm of the view President has every right to appoint somebody from the Southwest. It is his prerogative. But there are people from the Southwest in EFCC that have been trained and are better qualified for that job rather than bringing needless drama.
Okay, so just to you know, face the qualification thing as well, because it would seem that what you're doing is giving it a very narrow and very strict reading of the Section 2 of the EFCC Act. Now, we know that the EFCC is the Economic and Financial Crimes Act. Now, some people will say that the amount of work that the EFCC has to do in terms of economic sabotage, fraud, etc., demands many kinds of expertise. When Mr. Falana was making his case yesterday, he also argued that there is no lawyer who has worked with the EFCC as long as someone like Mr. Rotimi Jacobs, SAN, and that if such a person were to be appointed, for instance, will he be deemed not worthy or not qualified under this particular act, given the amount of experience that he has? So if you were to give it a very narrow reading, wouldn't we be depriving ourselves of talent that could actually serve the work of the EFCC?
You're right. That is the intention of the act, to make it narrow and to make it reclusive. It is the intention of the act. In the case of ICPC, you see they made it broad. It is intended because it's a specialized agency. Remember, police and DSS, they have similar. So that is why it is made narrow deliberately. That is point number one with respect to that. And then secondly, Rotimi Jacob SAN is the #1 prosecutor all of his life. If you call Rotimi now, his prosecution, they know that you will say fit the profile to become chairman. But because the act does not provide for somebody who does not belong, he was a legal practitioner for them, he was not a staff of the federal government, he cannot be recruited as the chairman of that agency. So the solution is they can go and amend in the future and then bring in a private lawyer. But if it is the act as it is presently constituted, it is deliberately meant to be restricted to people who come from either law enforcement or from intelligence. And these two, what I'm saying is that Olukoyede never had. The brief stint as secretary and chief of staff never afforded him the opportunity to have experience. Experience is the key word. And I asked my senior brother here, doctors used to advertise for medical doctors to be recruited into hospitals. They will say 15 years cognate experience. Can an accountant apply? Because in a short while, you see, even a mechanic to the cast of EFCC, if he has been doing mechanic for 15 years, he would have possessed cognate experience based on their interpretation to be made chairman.
So the point is, let me just say my last word. The point is that this dust will settle. Presently, there are two institutions that these matters are pending now before the Senate. The Senate have many lawyers. The president himself is an eminent lawyer. The leader is also an eminent lawyer. They will do the right thing. Then the matter is also before the court. So I believe that the court will give a proper interpretation to this matter and then let this matter settle. For God's sake.
Go to court. That's what they used to say. They will tell you go to court. APC, go to court.
Let's allow Ola to be the next chairman of EFCC.
Well, we can only go to break here. I want to thank both of you for coming on, Monday Ubani and Daniel Bwala, both lawyers. We're back in just a moment, everyone. Stay on with us.